This is Barry Zalma, Zalma on Insurance. Today I'd like to talk about the August 1, 2021 edition of Zalma's Insurance Fraud Letter, Volume 25, Issue Number 15. One of the articles in the August 1 issue is an article entitled "Refusal to Testify at Examination Under Oath is a Breach of a Condition Precedent." The Court of Appeal required a third trial of a breach of a condition precedent because of the failure of the trial court to enforce the condition requiring an insured to appear for an examination under oath. Generally, across the country, testifying at a properly noticed examination under oath, an EUO, is a condition precedent to coverage for any claim. In Safeco Insurance Company of Illinois versus Florimond Barthelemy, the Florida Court of Appeals on July 14, 2021, ruled that in its second trip to the Florida Court of Appeal, the insurer appealed a verdict in favor of the insured. The insured had filed a claim with his insurer seeking coverage for injuries sustained in an automobile accident. The insurer asked the insured for a statement regarding the accident, but the insured refused to give one. This prompted the insurer to investigate the insured's prior claim history. The insurer ran a report revealing multiple bodily injury claims. The excessive and extensive loss history caused the insurer to suspect fraud. As a result, the insurer asked the insured to submit to an examination under oath. The insured refused. The insurer scheduled 2 more EUOs, but once again, the insured refused or failed to appear. The insured's failure to submit to an EUO caused the insurer to deny coverage. It also refused to defend the insured against the other party's claims. The insured sued the insurer for declaratory relief, seeking coverage for the policy limits. The insurer moved for summary judgment, arguing that as a matter of law, the insured's failure to comply with the EUO condition constituted a material breach of the policy that caused the insurer substantial prejudice. The trial court denied the motion. The insurer raised fraud and breach of contract as affirmative defenses in the first trial. The jury answered 3 questions. 1. The insured failed to comply with his post-loss obligations. 2. The insurer was actually prejudiced by the insured's failure to comply. And 3. The insurer failed to prove the insured engaged in fraudulent conduct. Because the insurer proved the insured breached the contract with resulting prejudice, the trial court entered final judgment in its favor. The insured appealed, and the Court of Appeal in Florida concluded that the trial court erred in instructing the jury and reversed and remanded the case for a new trial. Before the second trial, the insured moved in limine to prevent the insurer from mentioning or implying the insured committed fraud or that the insurer suspected fraud. The insured argued that because the insurer did not cross-appeal the jury's unfavorable finding on fraud in the first trial, the issue could not be retried. The insurer responded that it needed to address fraud to show that the insured's material failure to comply with the EUO substantially prejudiced the insurer. The trial court reasoned that any reference to fraud was precluded by the previous verdict in the first trial. The trial court granted the motion in limine and ruled that no party was to mention or imply fraud or any wrongdoing on the part of the insured. At most, the parties and witnesses could use general terms like concerns. This time, the jury once again found the insured materially breached his post-loss obligations, but the jury found that the insurer did not prove substantial prejudice. The trial court entered a final judgment for the insured. The insurer moved for a new trial and for directed verdict, and the trial court denied both motions. And the insurer then appealed the second trial verdict. The insurer argued at the second appeal that the trial court erred in denying its motions for directed verdict and new trial because the trial court incorrectly excluded all evidence of fraud and wrongdoing. This prevented the insurer from proving substantial prejudice resulting from the insured's material breach of the policy. The insurer argued the question of whether it was prevented from conducting a proper fraud investigation was not settled as the law of the case. The appropriate standard of review applied to a trial court's denial of a motion for a new trial is whether the trial court abused its discretion. The doctrine of law of the case, a principle of a judicial estoppel, requires that questions of law actually decided on appeal must govern the case in the same court and the trial court through all subsequent stages of the proceedings. When the case was retried, the trial court excluded all evidence of the insured's wrongdoing and prevented the insurer from proving the insured's material breach substantially prejudiced its fraud investigation. The fact that the insurer demanded an EUO to investigate the possibility of fraud was relevant and material to determine substantial prejudice to the insurer. As the insurer argued, without the EUO, it had almost no information about the details of the accident that it could have used to assess and defend against the insured's liability. This information could have avoided all the litigation, including this case. The jury could not have possibly understood the importance of an EUO without knowing the insurer wanted to investigate insurance fraud. The purpose of an EUO is to enable the insurer to possess itself of all knowledge and all information as to other sources and means of knowledge in regard to the facts material to its rights, to enable it to decide upon its obligations and to protect itself against false claims. This was citing the decision of the U.S. Supreme Court in Claflin versus Commonwealth Insurance Company, which was decided in 1884 and is still the law of the United States. The trial court's ruling on the motion in limine impacted the witness's testimony, the documentary evidence, and the insurer's case. The trial court's exclusion of evidence and limitations on the insurer's argument directly related to the core issue of the case, whether the insurer's failure to cooperate prevented the insurer from conducting a meaningful fraud investigation. Indeed, an implication that the insured committed fraud would have been prejudicial. Nevertheless, the probative value of the highly relevant evidence outweighed the danger of unfair prejudice. Therefore, the case was remanded to the trial court so that the parties may try the case again for the third time. The Florida Court of Appeal, although reaching a correct result that reversed the trial court finding in favor of the insured, should have followed the decision of the U.S. Supreme Court in Claflin, found that the refusal to testify at an EUO was a breach of a material condition precedent, and entered judgment in favor of the insurer. Rather, it now requires Safeco to go through a third trial to again prove the breach of a material condition sufficient to allow it to refuse to pay neither defense nor indemnity. In addition, the August 1, 2021 issue of Zalma's insurance fraud letter contains an article about a convicted insurance fraudster who appealed a finding that she breached probation and wanted to avoid any potential for jail time. Instead, the court found that she breached the condition and sent her back to jail for just 9 months instead of the full 10 years she had been sentenced to and had been relieved of by probation. I'm always amazed at the unmitted gall, the chutzpah of those convicted of insurance fraud who used the courts to spend more time and money than the fraudster stole. Mrs. Heffington pleaded guilty to the crime. She was lucky she only had to serve 9 months of a 10-year sentence and leave the dentist she stole from alone. She couldn't resist. She harassed the dentist and tried to get the court with false evidence to remove her obligation to make restitution. She got caught again and was sentenced to only spend another 9 months in jail. And she appealed that. She should have been sentenced the full 10 years of her sentence, since the only reason her sentence was reduced was so that she could comply with the rules of her probation. Punishment needs to be real if it is to deter future wrongful conduct. In addition, the August 1 issue contains good news from the Coalition Against Insurance Fraud, listing multiple convictions of insurance fraud, articles concerning health insurance fraud convictions from the U.S. Department of Justice, among others, and a listing of other insurance fraud convictions other than health insurance, such as an article about Adam Haddad, a body shop owner who was sentenced for damaging cars to collect more insurance money, a Bradenton, Florida insurance agent who pled guilty to defrauding elderly investors, a Davenport, Iowa man who got 5 years in prison for insurance fraud, a former insurance agent who was sentenced for embezzling nearly $200,000 from clients, leaving them uninsured, another bad agent punished who owes $30,000 and has his license revoked, and a story about the jury convicting suspended Georgia Insurance Commissioner Beck on fraud and laundering charges, and a fraud conviction that blocked the naturalization application of the convicted person, which was sustained by, of all places, the Ninth Circuit Court of Appeal. There's also a listing of some of my books, including It's Time to Abolish the Tort of Bad Faith. This video was prepared from Zalma's Insurance Fraud Letter, which is available free from my website, zalma.com. by clicking on the link to the last 2 issues of Zalma's Insurance Fraud Letter, which is available free in Adobe PDF format. If you found this video to be of interest to you or your colleagues, please pass it on. It's also free. And please subscribe to my YouTube channel, my Rumble channel, my blog, and my Substack publications so that you can be advised of future videos and future blog postings. Thank you for your attention.